Welcome, curious minds, to the deep dive. Imagine this. You've got this brilliant business idea, or maybe you're a group of sharp professionals eager to collaborate. But then you hit a familiar dilemma. You crave the agility, the flexibility of a partnership, yet. Well, the terrifying thought of unlimited personal liability.
Right, where your own house could be on the line?
Exactly. That's a huge deterrent. Or maybe you've looked at forming a full company. Limited liability sounds great there.
But then you see the compliance rules.
Oh, yeah. The sheer mountain of rules, the rigid structure, it just feels overwhelming.
It's a classic balancing act, isn't it? For so many entrepreneurs, professionals too, how do you get the protection without sacrificing, the freedom and simplicity?
Precisely. So today we're taking a deep dive into a really ingenious business structure. It's designed specifically to tackle this problem. The Limited Liability Partnership, or LLP.
Governed by India's LLP Act, 2008.
That's the one. Our sources today, they're direct excerpts from this, game-changing piece of legislation.
Straight from the source.
Yep. And our mission, to cut through the legal jargon, pull out the most important bits of knowledge, and deliver those surprising facts, those aha moments.
So you can quickly grasp what an LLP is, why it even exists.
And what makes it such a compelling choice for businesses, for professionals all across India.
Okay, let's get into it.
So let's start right at the beginning. Why? Why did India need a completely new law for business partnerships back in 2008? What was, missing?
Well, the traditional partnership model, the one under the Indian Partnership Act of 1932, it came with that exact huge challenge, unlimited personal liability.
The scary part.
The really scary part. For countless professionals, consultants, small entrepreneurs, it was a massive barrier. I mean, your personal savings, your home, potentially at risk if the business tanks or faces a lawsuit.
Yeah.
On the other side, you had companies. They offered limited liability, which was fantastic, sure. But they operated under a much more rigid, statute-driven governance setup.
And the compliance...
Oh, the compliance costs and formalities were significantly higher. Just a lot more red tape.
So the LLP is basically designed to bridge that gap, like a best of both worlds solution.
Precisely. And what's really fascinating, I think, is that the LLP isn't just a slightly tweaked version of something else. It's a true hybrid.
A hybrid? How so?
It carefully blends the most appealing elements from both traditional partnerships and companies. Think of it as an alternative corporate business vehicle.
Okay.
It's specifically designed to give you the benefits of limited liability, plus the flexibility of organizing your internal stuff based on an agreement you all make.
Ah, like a partnership agreement.
Exactly, just like a traditional partnership in that sense.
Yeah.
The whole point was to let professional expertise and entrepreneurial spirit combine more freely, more efficiently.
Offering that protection.
Offering that crucial limited liability, but yeah, at a much lower compliance cost than a full company. It really did open up new ways for people to work together.
And you mentioned a key detail our sources point out. The old Partnership Act, the 1932 one, it just doesn't apply to LLPs.
Nope, not at all. It signals that this is a completely standalone legal framework.
Right, a separate thing entirely.
Absolutely. It's self-contained, a complete code. The LLP Act, 2008, it's comprehensive. It's got sections covering everything from setting one up to winding it down. And 4 important schedules dealing with practical things like what happens if there's no formal agreement between partners, or how old firms and companies can actually convert into an LLP.
And who oversee all this?
Ministry of Corporate Affairs and the Registrar of Companies, the ROC. So it's a consistent regulatory approach across India.
Okay, so for someone new to this whole idea, fundamentally, what is an LLP? What's its core identity?
Fundamentally, an LLP is recognized as a body corporate.
Yeah.
And it holds a separate legal entity status.
Separate from the partners.
Exactly. Distinct from its partners. And that's a huge deal. It means the LLP itself can sue, it can be sued, it can own property in its own name.
So it's not just the people involved.
Oh, it's not just a collection of individuals. It genuinely has its own independent legal standing, almost like a separate person in the eyes of the law.
And that separate identity gives it something else pretty powerful. Perpetual succession. What's that?
That's right. Because it is a separate entity, its existence isn't tied to any single partner. So if a partner dies or becomes unwell, retires, even goes insolvent, it has absolutely no impact on the LLP's existence or its continuity.
It just keeps going.
It just keeps going. Like a company in that respect, it offers tremendous stability, especially for long-term ventures.
Okay, so if it's separate, The big question, liability. This is where the limited liability part really kicks in, right? Setting it apart from old-style partnerships.
Exactly. The LLP itself, as an entity, is fully liable for its debts and obligations. So it's on the hook for the full extent of its assets.
Oh, okay.
But here's the game changer for the partners. Their personal liability is strictly limited to the capital they've agreed to contribute to the LLP. That's it. This shields partners from joint liability if another partner messes up or engages in misconduct.
So one bad apple doesn't spoil the whole barrel, financially speaking.
Precisely. Think of professionals, consultants, lawyers, accountants. Before LLPs, they might have hesitated to form partnerships because one partner's error could financially ruin everyone else.
Right. I can see that.
Now, with an LLP, they can take on ambitious projects without that constant fear hanging over them, the fear of losing their personal assets.
That sounds like a massive relief, especially for collaborative professional work. But how does the internal governance work? Is it still like a traditional partnership where one partner can bind all the others legally?
Ah, that's another critical distinction and a key benefit. In an LIP, the mutual rights and duties, how the partners operate together, are governed by a flexible agreement they create themselves.
The LLP agreement.
Yes, the LLP agreement. This freedom to customize is very much like a traditional partnership. But here's the crucial difference regarding liability. A partner acts as an agent of the LLP itself.
Okay, the entity.
Right. But not as an agent of the other partners individually.
Meaning
One partner's actions or decisions won't automatically legally bind another individual partner. It's a huge departure from traditional partnerships where any partner's act binds the firm and, by extension, every other partner.
fascinating. So it really behaves like its own legal person.
Yes, it's often described as an artificial legal person. It doesn't have human traits, obviously can't be jailed, can't get married,
Right.
but it has legal rights and capacities. It can own assets, make contracts, be part of legal proceedings, all in its own name.
Does it need like a company seal, that sort of thing?
It may have a common seal, which acts as its official signature,
Yeah.
but it's not mandatory anymore. If it does choose to use one, it needs to be affixed in the presence of at least 2 designated partners.
Okay.
And one more key thing. An LLP must be formed to carry on a lawful business with a view to earn profit. It can't be set up purely for charitable or nonprofit aims.
Got it. So who can actually be a partner in an LLP? Are there restrictions?
Well, it's pretty broad, actually. Any individual or anybody corporate, meaning another company or even another LLP, can be a partner.
Any exceptions for individuals?
Yes, a few specific ones. Individuals declared of unsound mind by a court, undischarged insolvents, or anyone who has applied to be declared insolvent, they cannot be partners.
Okay.
And an interesting little detail the Act specifies. A Hindu undivided family, an HUF, cannot be a partner in an LLP.
Right. And what about numbers, minimums, maximums? And I keep hearing about designated partners. What's their specific role? It sounds important.
Okay, numbers first. Every LLP must have at least 2 partners. Minimum of 2.
And maximum.
No maximum limit. That offers fantastic flexibility. You could have a 2-person startup or a massive professional firm with hundreds of partners.
But what if it drops below 2?
Ah, good question. There's a safety net. If an LLP somehow operates with only 1 partner for more than 6 months, that single remaining partner then becomes personally liable for the LLP's obligations incurred during that solo period.
Okay, so the law makes sure there's always at least shared responsibility, effectively.
Pretty much, yes. Now, about designated partners, or DPs.
Yeah, what's their deal?
They're essentially the compliance officers of the LLP. Every LLP has to have at least 2 individuals acting as designated partners.
Individuals specifically, not companies.
Individuals.
Yeah.
And crucially, at least one of these DPs must be resident in India.
Meaning
They've physically stayed in India for at least 120 days during that financial year.
Okay. What if all the partners are companies?
Good point. If all partners are body corporates, then nominees, individuals nominated by at least 2 of those corporate partners, must act as the designated partners.
So they're the ones on the hook for the legal stuff, the filings, the compliance.
Exactly. DPs bear the primary responsibility for all the legal compliance under the LLP Act. Filing documents, annual returns, all that nitty-gritty. They are the ones liable for penalties if the LLP breaks the rules.
Do they need special registration?
Yes, they must get a designated partner identification number, a DPI, similar to a director identification number for company directors.
And are there penalties if you don't have the right DPs?
Oh, yes. The law has teeth. Significant penalties for noncompliance, like operating with fewer than 2 DPs or not having a resident DP. Fines can go up to, say, $100 for the LLP and $50,000 for the defaulting partners. It ensures clear accountability.
So, okay, for you, the listener, the aspiring entrepreneur,
Yeah.
if you're thinking, right, an LLP sounds good, what's the actual process? How do you set one up?
The process is actually pretty streamlined now, mostly digital, which is good news.
Right.
To start, you need at least 2 people or entities who want to run a lawful, profit-making business. They subscribe their names to what's called an incorporation document. This document, plus a statement confirming all the legal requirements are met. This statement needs to be made by a professional, like an advocate, a company secretary, a CA, or a cost accountant involved in setting it up, and by one of the subscribers.
Right, a declaration of compliance.
Exactly. That all gets filed electronically with a registrar of companies. If the registrar is satisfied, they register it and issue a certificate of incorporation,
How long does that usually take?
typically within about 14 days. And that certificate is your conclusive proof the LLP is officially born.
So practically speaking, it boils down to a few key online steps.
Essentially, yes. For
Yeah.
you thinking of starting one, it's basically step 1, reserve your chosen LLP name using an online form, RUNLLP.
Okay.
Step 2, file the main incorporation e-form called Philip. This includes all the details, the LLP, the partners, their consent forms.
Got it.
And step 3, this is crucial and mandatory.
Ah.
Execute the LLP agreement. That's the contract between the partners. And you have to file that agreement using e-form 3 within 30 days of getting incorporated.
Don't forget that last step. And what about the name itself? Any rules there?
Yes, definitely rules. Every LLP name must end with either the full words Limited Liability Partnership or just the acronym LLP.
Clear enough.
Also, the name can't be undesirable in the government's view, and critically, it can't be identical or too similar to an existing LLP, an existing company, or a registered trademark.
So you need to check that first.
Absolutely. Once your name gets approved, the registrar reserves it for you for 3 months. That gives you time to get the rest of the incorporation sorted.
What if somehow a name slips through that's too similar? Can it be fixed later?
Yes, there's a mechanism for that. If an LLP gets registered with a name that's deemed too close to another LLP company, or registered trademark, importantly, not a traditional partnership firm, though the central government can't step in,
How?
they could direct the LLP to change its name, usually within 3 months. This might happen if the existing entity complains.
And if the LLP doesn't change it?
If they default, the central government has the power to actually assign a new name to the LLP itself. The registrar then issues a fresh certificate with that new government-assigned name. So yeah, naming is a serious compliance point.
Okay, so the LLP is formed, it's got its name. What about ongoing financial responsibilities? Compliance. How does it stay accountable?
Right, day-to-day operations. LLPs must maintain proper books of account. This has to be done at their registered office, covering each year they exist.
What system do they need to use?
They can use either a cash basis or an accrual basis, but it must be a double-entry system. Standard accounting practice, basically. This ensures financial transparency.
And filings?
Yes, they have to prepare and file a statement of account and solvency. Think of it as a snapshot of their financial health. That needs to be filed within 6 months after the end of each financial year.
Is there an annual return, too, like with companies?
You got it. An annual return must be filed with the registrar within 60 days of the financial year closing.
Do the accounts need auditing?
Generally, yes. The accounts usually need to be audited. However, the central government does have the power to exempt certain classes of LLPs from the audit requirement. So maybe smaller LLPs might get a pass, offering some relief.
And are there penalties for missing these filings?
Oh, definitely. And they can add up quickly. For things like not filing the annual return, it's often a daily penalty, say 100 PSI per day, for both the LLP and the designated partners.
Wow, that adds up.
It does. There are maximum caps, but they're significant, up to 100,000 for the LLP and euro 50,000 for the DPs, just for that one failure. It's a strong incentive to stay compliant.
What about public transparency? Can anyone see these filings? And what if someone tries to fudge the numbers?
Transparency is a key feature. The incorporation document, partner details, the statement of account and solvency, the annual returns, these are all public documents. Anyone can inspect them.
Fosters trust, I suppose.
Exactly, and accountability. As for fudging the numbers or providing false information in any required document, the consequences are severe.
Like what?
We're talking potential imprisonment for up to 2 years, plus significant fines ranging from $100,000 up to $500,000. The registrar also has powers to investigate, demand information, even summon people if needed.
So they can dig deeper if something looks off.
Absolutely. Though, interestingly, for less serious offenses, those punishable only by a fine, there's a process called compounding.
Compounding.
Yeah. The regional director can allow the LLP or partners to settle the offense by paying a specified penalty, avoiding a full prosecution. It streamlines things for minor breaches.
Okay, that brings us back to liability. We talked about limited liability being the big draw, but you hinted it's not always absolute. When can that limited liability shield suddenly become, well, unlimited?
This is a really crucial point, something anyone involved in an LLP needs to understand clearly.
When does that protection disappear?
It disappears if an act is carried out by the LLP or by any of its partners with a clear intent to defraud creditors or for any other fraudulent purpose.
So deliberate fraud basically breaks the shield.
Exactly. In that scenario, the limited liability protection is completely lifted. The liability of the LLP and every partner involved in that fraudulent act becomes unlimited for all the debts and other liabilities that result.
And the penalties for the fraud itself?
Also severe. Besides the unlimited liability, the fraudulent act itself can lead to imprisonment for up to 5 years, plus those hefty fines we mentioned, $50,000 up to $500,000. It's a very strong deterrent against misconduct.
But what if it's just one rogue partner acting fraudulently without the others knowing? Is the whole LLP still on the hook?
That's an important distinction the law makes. If a partner acts fraudulently without the LLP's knowledge or authority, the LLP entity itself is generally not liable to compensate third parties for that specific fraudulent act. It protects the innocent partners and the entity itself from unauthorized wrongdoing.
So the law tries to isolate the liability to those actually involved in the fraud. Makes sense. What about encouraging people inside the LLP to report problems? Is there anything like whistleblower protection?
Yes, absolutely. The law actively encourages transparency and ethical conduct from within.
How so?
Courts or tribunals have the discretion to reduce or even completely waive penalties for any partner or employee who provides useful information during an investigation into the LLP's affairs.
So if your information helps catch wrongdoing.
Right, or if your information leads directly to someone being convicted, you might get leniency on any penalties you might otherwise face.
And does it protect them from retaliation?
Yes, crucially it does. The Act specifically prohibits the LLP from discharging, demoting, suspending, harassing, or discriminating against any partner or employee just because they provided such information. It's a vital protection to encourage people to speak up.
That's good to hear. Okay, let's shift gears a bit to the life cycle of an LLP. How flexible is it? Can structures change? Can LLPs merge? What happens when one needs to, well, end?
The LLP Act provides quite a bit of flexibility here. For starters, conversions are possible. Yeah, a traditional partnership firm, a private company, or even an unlisted public company can choose to convert into an LLP structure.
Really? How does that work with assets and debts?
When that conversion happens, all the property, all the assets, and importantly, all the liabilities and obligations of the old entity automatically transfer over to the new LLP.
Seamlessly.
Legally, yes.
Mm-hmm.
And the old entity, the firm or the company, is then considered dissolved. The new LLP just needs to inform the previous registrar, whether of firms or companies, within 15 days about the conversion.
That seems like a useful option for existing businesses wanting the LLP benefits. What about partners wanting to sell their share or LLPs joining forces?
Partners can transfer their economic rights, their right to share in profits and losses. This gives them some liquidity.
But does the buyer become a full partner?
No, that transfer of economic rights doesn't automatically make the buyer a partner with management rights, nor does it mean the original partner leaves the LLP. It's just a financial interest.
Okay. And mergers?
LLPs can enter into compromises or arrangements with creditors or partners, which need to be sanctioned by the tribunal, similar to companies. Reconstruction and amalgamation between LLPs are permitted.
But can an LLP merge with, say, a regular company?
No. That's a specific limitation. An LLP cannot amalgamate with a company under the current framework. There would need distinct legal forms in that respect.
Interesting. So when does an LLP actually wind up or dissolve? What triggers the end?
An LLP can cease operations in two main ways. Voluntarily, if the partners all agree to wind it up.
Okay.
Or compulsorily, by an order from the tribunal.
And what would make the tribunal order a winding up?
Several circumstances. If the LLP itself passes a resolution asking the tribunal to wind it up, or, remember the minimum partner rule, If the number of partners falls below 2 and stays that way for more than 6 months,
Right.
more serious grounds include if the LLP acts against India's sovereignty, integrity, national security, or public order.
Okay, national interest issues?
Exactly. And a very practical trigger. Failing to file the statement of account insolvency or the annual return for 5 consecutive financial years, that's seen as a sign the LLP is effectively defunct or non-compliant.
5 years is a long time to not file.
It is. And finally, the tribunal has a general power to wind up an LLP if it considers it just and equitable to do so, which covers various other potential situations.
Okay, so we've covered a lot of ground formation, liability, compliance, winding up. For you, the listener, trying to make sense of all this, what's the bottom line? Why would you specifically choose an LLP over, say, a traditional partnership, or even over a company? Let's really break down those core distinctions.
Right, this is the so what moment. Where does the LLP fit in your decision-making? It really does carve out a unique and, I think, very appealing niche.
Yeah.
Let's start comparing it head-to-head with a traditional partnership firm.
Okay, lay out the key differences for us. Hit me.
Difference number one, the absolute fundamental legal status. An LLP is a separate legal entity. It has perpetual succession.
Meaning it's its own person, legally, and can outlive the partners.
Exactly. It can own property, sign contracts in its own name. A traditional partnership, not a separate entity. It's just the partners collectively, and its existence is tied directly to them. So the LLP is far more stable, more enduring as a structure.
In liability, the big one we started with.
The defining difference, absolutely. LLP partners get limited liability. Your personal risk is capped at what you agreed to put in. Traditional partners, unlimited liability. Your personal assets, house, car, savings, all potentially on the line for business debts.
That alone seems like a game changer for many.
It is. Then there's mutual agency. In an LLP, remember, a partner is an agent of the LLP entity, not the other partners. So one partner's actions don't automatically bind the others personally.
Whereas in a traditional firm,
Any partner can bind the firm and all the other partners by their actions. Much higher risk exposure for everyone.
okay, liability and legal status are clear wins for LLP there. What about the admin side? Registration, filings.
LLP registration is mandatory. You have to register. And it comes with mandatory annual filings, the statement of account insolvency, the annual return. This ensures transparency and compliance.
And traditional partnerships?
Registration is often voluntary, and generally no requirement for annual filings with the registrar firms. Less regulation, yes, but also less formal structure and potentially less credibility.
And LLPs have those designated partners for compliance.
Right, a specific role focused on compliance, which traditional firms lack. Also, a practical point for global business. Foreign nationals can easily be partners in an LLP. That's generally not the case for traditional Indian partnerships.
Okay, that makes the LLP look very attractive compared to a traditional partnership, especially if liability is a concern. But how does it stack up against a full private limited company? They also offer limited liability.
Good question. Here, the trade-off is mainly about flexibility versus stricter regulation. An LLP's internal governance is incredibly flexible. It's largely dictated by that private contract, the LLP agreement, that the partners create. You can tailor it quite a bit.
In a company,
A company is governed by the Companies Act, 2013. It's a much more rigid, statute-based system with prescriptive rules for meetings, directors, resolutions, share structure, much less wiggle room.
what about how they're managed?
LLPs are typically managed directly by the partners, especially the designated partners. It's more hands-on. Companies are managed by a board of directors, elected by shareholders, so there's often a separation between ownership, shareholders, and management directors.
Makes sense. Any difference in the number of people involved?
Yes. LLPs need a minimum of 2 partners, but remember, no maximum limit. Great for scaling. Private companies also need a minimum of 2 members, but are capped at a maximum of 200. Public companies have higher minimums, but no maximum, but they come with much heavier regulatory burdens.
And the liability itself. Both are limited, but is it exactly the same?
Similar concept, slightly different basis. In an LLP, partners' liability is limited to their agreed capital contribution. In a company, members' liability is typically limited to the unpaid amount on the shares they hold. So the mechanism is slightly different, though the outcome personal asset protection is largely the same.
Right. So you've just seen how the LLP carves out this really unique, really powerful space in India's business landscape. We've navigated the intricacies of the LLP Act 2008.
Dug deep into it.
Yeah, discovering how it masterfully offers that compelling blend, partnership flexibility on one hand, and the vital protection of corporate limited liability on the other.
From its identity as a hybrid entity, the roles of DPs, the consequences of fraud.
Exactly.
Yeah.
You should now have a solid, actionable foundation for understanding LLPs.
It really is a testament to how legal frameworks can evolve, adapting to meet modern business needs, offering these tailored solutions.
Absolutely. So the next time you find yourself sketching out a new venture, or maybe thinking about how an existing business could be structured better, more protected, I encourage you to consider this. How might this specific blend, this powerful mix of flexibility and protection offered by an LLP, how might that unlock entirely new possibilities for collaboration, for innovation, for your specific business goals?